We're in Royal Oak, Michigan. It's around 10:40 a.m., and police just witnessed the driver of this SUV throw a cigarette out the window. Moments later, the driver makes a turn without signaling, then accelerates beyond the speed limit. After officers pulled the vehicle over, they reportedly noticed the odor of alcohol coming from inside. The driver's then removed and ordered to perform a set of field sobriety tests.
What I want you to do is I want you to focus on the tip of my finger. It's going to move side to side. Focus on it with your eyes and keep your head still, okay? Keep your head still. What I want you to do is I want you to picture an imaginary line in front of you. Place your left foot on the imaginary line. Now, you're going to take 9 heel-to-toe steps out along that imaginary line, counting your steps out loud. You can start whenever you're ready. Not going to be able to do it? No. You want to try?
Let's call that strike one.
Next, I want you to count backward from 54 to 37. Do you understand? Mm-hmm. Okay, go ahead. Whenever you're ready.
54, 53, 52, 55, 50, 49, 48, 46, 47, 46, 48, 39, and 37.
37. Okay.
There's strike two.
All I need you to do is wrap your lips around this tube. You're going to blow up to it just like this. You don't have anything to tell your mouth, right? You might have to take a look real quick. All right.
As they wait for the breathalyzer results, the officer asks the driver a sobering question.
Do you think you should be driving right now? Do you have kids?
No, I have kids.
If you had your kids in the car, would you be driving right now?
No.
Can you read that out loud for me?
And strike three.
0.112. So the legal limit is 0.08. So at this point, I am going to place you under arrest for operating while intoxicated. I'm going to have you turn around, put your hands behind your back, and interlace your fingers.
Sir, are you bringing me to jail?
I am.
What so far has been a pretty typical traffic stop and arrest takes an interesting turn when the driver tries to plead her case.
Is there any way, I'm really gonna, I don't drink and drive. I'm running for an office right now.
Okay.
This will f me up really bad. I'm running for an office right now.
And not just any office. 49-year-old Julie McDonald is a local attorney, and she's running for county circuit court judge.
This will f me up really bad.
You know, there's not a lot of discretion I have with something like this.
No, I understand.
I can't bend the rules.
Around 11:45 a.m., McDonald arrives at the police station and tells officers she'd consumed 4 vodka drinks the night before and agrees to another breathalyzer test. This one reads 0.08, which is exactly Michigan's limit and technically considered drunk driving, but also falls within the test's 0.004 margin of error. McDonald would later plead guilty to careless driving and littering for tossing the cigarette out the car window in exchange for the dismissal of the drunk driving charge. She was required to pay $2,000 in court fees, continue daily testing for alcohol use, and complete 40 days of community service. As for her bid for county circuit court judge, it was a success. But 8 months after she was arrested, the Michigan Supreme Court ordered a 45-day unpaid suspension for her misconduct behind the wheel. Next, we're in Topeka, Kansas for a Supreme Court disciplinary hearing for attorney Dennis Hauver. The defense lawyers at the high court a year after a state review panel called for his disbarment, citing, among other things, professional incompetence in his handling of a capital murder case. Laying out the details of the panel's findings is the deputy disciplinary administrator for the courts. He claims Hauver had no business taking on a capital murder case to begin with.
Respondent only experience in a murder case was some 20 years prior to that. That was not a capital case. He really had no idea of the law of capital murder, the capital murder trial proceedings.
And what is your recommendation for what we should do today?
My recommendation is that you approve the discipline of disbarment.
With serious allegations leveled against him, and with his law license on the line, it is imperative for Hoover to present a professional rebuttal to the Supreme Court.
I appear before you today dressed as Thomas Jefferson, who's my hero among the founders.
That's right, donning a powdered wig, an 18th century suit, and white stockings, Dennis Hoover will now argue his professional competency in the state's top court.
I wore this outfit because today the United States Constitution protects my rights to try the case as my client and I agree.
The case in question was the capital murder trial of Philip Cheatham. The 30-year-old was charged with shooting 2 women to death and attempting to kill another during a home invasion. Cheatham had a long criminal history, including a previous manslaughter conviction for shooting and killing a man during a drug deal. Most defense attorneys would not want to introduce that history at trial, but clearly Hoover is not most lawyers.
My client was a criminal for a living.
While possibly an unorthodox defense strategy, Hoover claims it was not incompetent.
Don't forget, Philip Cheatham didn't complain about my performance or conduct. You did.
The jury ultimately found Philip Cheatham guilty of the murders and sentenced him to death. Following the hearing, the Kansas Supreme Court upheld the state panel's findings and disbarred Kenneth Hoover for what they called, quote, inexplicable incompetence. As for Philip Cheatham, the defendant in the capital murder case, he was granted a new trial due to ineffective assistance of counsel. He ultimately pleaded no contest to the murders in exchange for having the death penalty dropped. He was resentenced to life in prison with eligibility for parole after 25 years for the capital murder charge and received a consecutive 13-year, 9-month sentence for attempted murder. For our next story, we go to a bond hearing taking place via Zoom in Florida's Broward County. Like so many workplaces affected by COVID-19, the parties are forced to communicate virtually.
Mr. Mitchell, good morning. Are you able to hear me all right?
No.
Today, the defendant is Henry Mitchell. He's charged with grand theft. Mitchell allegedly stole over $4,000 from a local restaurant. He's hoping to be released on bond of $1,000. The judge is Corey Amanda Cawthon. There's Mitchell up in the top corner. And we've got attorney Eric Linder, who represents the state, and assistant public defender Dale Miller.
All right, Mr. Mitchell, you're before the court this morning on one charge of grand theft. I do find probable cause, and I will first hear from the attorneys with their recommendations. We'll start with Mr. Linder.
Judge, I'm recommending a $5,000 bond and no return. While I see no priors, I do believe this is obviously not your run-of-the-mill grand theft.
Oh, you, Linder. Who cares what you have?
Mr. Miller, excuse me, but your microphone is on, and if we have one more outburst like that, we're going to be having a very serious discussion with your supervisor. I would expect that you would apologize to Mr. Linder right now.
As Linder recommends a $5,000 fine, Miller turns his camera off, but not his microphone, and expresses his true feelings.
This is obviously not your run-of-the-mill grand theft.
Oh, you, Linder. Who cares what you have?
Miller's language gets some stunned reactions, specifically from the family of the defendant and from Linder himself.
Mr. Miller, excuse me, but your microphone is on. I would expect that you would apologize to Mr. Linder right now.
After a brief pause, Miller offers an apology. Sort of.
Turn the
I
microphone.
apologize that my microphone was on, Judge.
You know, he should be sanctioned.
We'll be having a discussion with Mr. Goldberg after the session today. Mr. Linder, let's continue with Mr. Mitchell's case.
Your Honor, as I was saying, this is not your run-of-the-mill grand theft. The strength of the evidence against Mr. Mitchell is abundantly strong, including but not limited to his confession.
Linder still seems agitated by the attorney's outburst, but forges ahead.
Your Honor, he plotted with his co-arrestee well in advance to not only steal over $4,000 from this business, but to set it up to make it look like there was an armed robbery. Your Honor, I would also note, by his own admission, he stole over $2,000 in cash from the safe from the business, and the cash has not been recovered. Nothing further, Your Honor.
Finally, the judge is ready to make her decision.
In Mr. Mitchell's case, the monetary bond is going to be set at $3,000 and there will be an order of no return. Mr. Mitchell, that simply means you're not to go to that location for any reason. Do you understand that, sir?
Yes, ma'am.
Okay, thank you and good luck to you as well.
All right, Yanel Morales.
Next, we're in Fort Lauderdale, Florida for a bond hearing. 32-year-old Yaneli Marie Morales was charged with burglary with assault or battery for breaking into the home of a woman who was allegedly having an affair with her boyfriend. The crime is punishable by up to life in prison. So the public defender, who's off camera, asks to have his office's appellate attorney present when it comes time to rule on the defendant's bond.
I've contacted our appellate attorney that wants to be present and make arguments. They're only available this afternoon. I'm just respectfully asking if the court could give us that courtesy for him to be present at 1:30 and make those arguments.
Judge Michael Davis is not opposed to the request. Problem is, he wants to move things along.
All right, the public defender's office wants to make legal argument. They've got to be prepared to make legal argument. Docket starts at 8:30. It's now 9:45. All right, Ms. Morales.
Judge, can I just have one moment, please?
Sure.
After consulting with his colleagues, the public defender lets the judge know the other attorney is actually on her way.
How long?
A few minutes. She's on her way.
All right, we'll pass it. Have a seat, ma'am.
But after waiting about 20 minutes with no sign of the attorney, things start getting awkward.
The public defender's office is about a 2-minute walk away. Your colleague is not here. It's 20 minutes later. I'm going to call Miss Morales' case back. Yaneli Morales. All right. Good morning, Miss Morales. You're charged with a burglary with assault or battery. I'm going to find probable cause for that offense, ma'am.
The state is asking that Morales be held without bond. But before continuing, the public defender again asks to have the office's appellate attorney present.
Your appellate attorney asked to be here 20 minutes ago, and she is not here.
Judge, but
it
now
shows a blatant disrespect to this court.
Judge,
think, Mr. Armstrong?
No.
It's about a 2-minute walk from the public defender's office. Where is your colleague?
Judge, may I have just 1 minute?
Nope.
I would like to have a supervisor present.
By now, it seems the focus has shifted from the case at hand to a debate between judge and public defender.
Your office is here. You are here. I've given your office the courtesy to come down here. Your colleague has apparently hung you out to dry. I'm not really sure why, but you're now making conflicting arguments.
I'm not saying the court.
I'm asking you to explain this inconsistency.
Judge, what I'm saying to the court
I need
is
you to answer that question.
But when the public defender still can't answer his question, Judge Davis loses his temper.
What I'm saying to the...
All right, we're all done then. All right. State anything else? Ma'am, you're going to be held without bond at this time. Good luck. All right.
But 3 days later, at her next hearing, Yaneli Marie Morales was released on a $10,000 bond and is currently awaiting trial.